Please take note, students are only allowed to underline the sections of the Act in their textbook with pencil, and the slides in this recording include snippets from the Act. These snippets have been coded in a manner described on the slide in order to enhance students' understanding to what is important and for ease of reading. A share issued by a company is movable property that is transferable. A share doesn't have a nominal or par value, and a company may not issue shares to itself. The company's MOI must set out the classes and number of shares that is authorized to issue, the name of each class of share and the preferences, rights and limitation of each class of share. The aforementioned may only be changed by an amendment of the MOI by a special resolution or by the board of the company, except to the extent that the MOI provides otherwise. All shares within a class of shares will have the same preference, rights and limitations. Each issued share has a general voting right, which means that the shareholder can exercise their vote at the shareholders' meeting, unless the MOI provides otherwise. However, a voting right can be limited but not taken away entirely. The board of a company may issue shares at any time, if the shares are authorized in terms of the MOI. In the case of a private company, each shareholder has a right to shares issued by the private company before any other person who is not a shareholder. For example, if you have 35% general voting shares of the company's shares and the company wishes to issue 1,000 new shares, you as a shareholder have the preemptive right to 350 shares or less, which a non-shareholder will not have. This section does not apply to public or state-owned companies. The board of a company may only issue authorized shares if it is either for adequate consideration, in terms of conversion rights associated with previous issued shares, or as a capitalization issue. Only once the shares have been issued and paid will the shareholders' details be entered to the securities register. If shares are issued to a director or future director, prescribed officer or future prescribed officer, or a nominee or person related or interrelated to these parties, the issue of these shares must be approved by a special resolution. A special resolution will not be required under circumstances listed in subsection 2. A company may issue options for the allotment or subscription of authorized shares. The board may authorize to issue unsecured or secured debt instruments which may grant special privileges to the holder, unless the MOI provides otherwise. Financial assistance, in example, a loan, guarantee, provision or security, may be provided to any person to buy securities in the company or a related company, provided that all conditions and restrictions in respect of granting financial assistance as set out in the MOI are adhered to. The board must be satisfied that, firstly, the company would satisfy liquidity and solvency tests immediately after providing the financial assistance. Secondly, that the terms of the financial assistance provided must be fair and reasonable. A special resolution must also have been passed within the past 2 years, but is not required if the financial assistance is granted in terms of an employee share scheme. The requirements of this section does not apply to companies whose primary business is the lending of money. Also refer to the extract of auditing notes, providing an additional explanation on this slide. Section 45. A company may provide direct or indirect financial assistance to a director or prescribed officer of the company or related party, or to a related or interrelated company, a member of a related or interrelated corporation, or any such person related to such corporation, company, director, prescribed officer, or member. The following requirements are similar to Section 44 and should be studied together. All conditions, restrictions in respect of granting financial assistance set out in the MOI must be adhered to. The board must be satisfied that, firstly, the company would satisfy liquidity and solvency tests immediately after providing the financial assistance. Secondly, that the terms of the financial assistance provided must be fair and reasonable. A special resolution must also have been passed within the past 2 years, but is not required if the financial assistance is granted in terms of an employee share scheme. The requirements of this section does not apply to a company whose primary business is the lending of money. The aforementioned requirements, similar to section 44, are however not applicable if the financial assistance provided are to cover legal expenses of the company or anticipated expenses incurred on behalf of the company, or is issued to cover the recipient's expenses that were incurred at the company's request. If the board adopts a resolution to provide financial assistance to directors as implied in this section, they will need to notify all shareholders and any trade union representing employees. When to notify would depend on the total of the financial assistance provided. If the total value of the financial assistance given is more than 1/10 of 1%, in example, 1% of the net worth of the company at the time of the resolution, the notification must be within 10 business days after the board adopted the resolution. And if less than 1%, it should be within 30 days after the financial year end. Guidance is provided on this slide on how section 44 and 45 can be summarized by students. A distribution has a defined meaning in the Act. It amounts to a transfer of money or other property to or for the benefit of one or more holders of company shares or another company within the same group of companies. A person receives a distribution by being a shareholder, and examples include dividends, payments instead of capitalization shares, share buybacks, incurring debt for the benefit of a shareholder, or cancelling a debt owed by a shareholder. The company may only make a distribution if there's an existing legal obligation or court order, or the board has passed a resolution authorizing the distribution. And after the distribution, the company would satisfy liquidity and solvency tests. And the resolution states that the directors applied the solvency and liquidity test and concluded that the test requirements were satisfied. If the distribution is not made within 120 days, the board must reconsider the solvency and liquidity test, and a further resolution must be adopted. It is important to note here, a director can be held liable in terms of section 77 of the Act if he or she was present at the meeting but failed to vote against the decision, knowing it was contrary to the requirements of this section. This section deals with capitalization shares, and the board of a company, by resolution, must approve the issuing of any authorized shares as capitalization shares. As seen in section 46, a share buyback is regarded as a distribution. Thus, if the board of a company acquires a number of its own shares, all requirements of section 46 must be met. If the board of a subsidiary company acquires shares in its holding company, it will also need to satisfy the requirements of section 46. However, the board of a subsidiary company may not acquire more than 10% of the total issued shares of any class of shares of the holding company, and voting rights related to these shares may not be exercised.